If you could come forward. Thank you, Selena. You see the time and start when you're ready.
Thank you. Good evening, members of the Policy and Bylaw Committee. My name is Selena Hamilton, and I wish to speak to you tonight regarding the Ontario Human Rights Code and the Greater Essex County District School Board's policies and regulations applicable to gender identity and expression. The Ontario Human Rights Code recognizes that each person has a right to equal treatment in the areas of housing, contract, employment, goods and services, facilities, and membership, regardless of age, ancestry, color, race, place of origin, citizenship, creed, disability, marital status, gender identity, sex, and sexual orientation. I'm here to express my concerns regarding certain policies and regulations that have been implemented within our education system, and I believe it is essential to consider how these policies impact the dignity and respect of all students. The Ontario Human Rights Code does not at any point stipulate that new services, facilities, housing, or preferential treatment be provided to any person based on immutable or variable traits. The truth is we are all protected under the Human Rights Code, and no person may infringe on the rights of others or subject them to bullying, harassment, or discrimination. It is important to recognize and respect the unique needs of every student. However, I'm concerned about the current approach that categorizes biological females identically with males who identify as female. Many biological females may feel uncomfortable or stripped of their dignity when required to share private spaces such as washrooms with males. This situation can lead to breaches of privacy, respect, and safety. Furthermore, I am worried about the potential risks associated with allowing males in female washrooms and the impact this might have on the physical and sexual safety of girls. Stripping a person of their consent and volition goes far beyond bullying. It is a form of oppression. The school board has no reason to create barrier-free access to washrooms and change rooms. Segregation by sex is addressed in Section 20 of the Ontario Human Rights Code. It reads, under restriction of facilities by sex, the right under Section 1 to equal treatment with respect to services and facilities without discrimination because of sex is not infringed where the use of the services or facilities is restricted to persons of the same sex on the ground of public decency. It is also deeply concerning to consider the impact on girls when they are forced to compete against male peers in sports. The situation can be seen as a form of bullying, as females are often outmatched in size and strength by their male counterparts. Additionally, it can lead to discrimination, as females may find it difficult to excel in athletics when competing with males. Furthermore, discrimination is also perpetuated when females are prohibited from participating in extracurricular activities due to concerns for their own safety. Additionally, the school board is attempting to protect a student's expression of their lived gender identity while simultaneously creating two lives for the students, one at home and one at school. Encouraging this divide in identity can create mental and emotional instability, as well as lead to alienation from their family due to secrecy. Gender dysphoria is still considered a mental health condition in the Diagnostic and Statistical Manual of Mental Disorders of the American Psychiatric Association. Is the school board licensed to diagnose and treat mental health conditions? Are school principals, teachers, and staff prepared for litigation to follow when they create and execute a gender expression plan for a minor without medical or parental consultation? I remind the school board that parents have full rights to their child's municipal records as upheld by the Municipal Freedom of Information and Protection of Privacy Act, the Ontario Student Record Guideline, and the Education Act. The OSR Guideline, paragraph 4.2 states the parents of the student have the right to have access to the student's OSR until the student becomes an adult, age 18. Under both the Children's Law Reform Act and the Divorce Act 1985, the legal right of a non-custodial parent to have access to a child includes the right to make inquiries and to be given information concerning the child's health, education, and welfare. The Education Act, Section 266, states under pupil records, paragraph 3, a pupil and his or her parent or guardian, where the pupil is a minor, is entitled to examine the record of such pupil. Paragraph 4, where in the opinion of a student who is an adult or the parent or guardian of a pupil who is a minor, information recorded upon the record of the pupil is inaccurately recorded or not conducive to the improvement of instruction of the pupil, such pupil, parent, or guardian, as the case may be, may in writing request the principal to correct the alleged inaccuracy in or remove the impugned information from such record. This means that neither the student, the school staff, nor the school board may fabricate records or withhold records from parents. If teachers or staff identify a debilitating mental or emotional condition in a student, protocols are in place that begin with the involvement of parents, family doctors, and child services. Similarly, if teachers or staff suspect abuse at home, established procedures are triggered involving police, parents, and child services right from the start. I hope this committee understands that altruistic policies and regulations do not override provincial and federal law. Parents retain absolute authority over their children and have legal recourse for any damages caused by duplicitous education system. Thank you for your time and consideration in this matter. And thank you for the extra time.
No worries. Thank you for that. And I'm going to ask Trustee Cook and Trustee Hatfield if they have any questions or clarification whatsoever. Questions?
No, thank you.
Okay, thank you. I have one question.
Yes.
And I'm just wondering if you've ever inquired with WEX about your concerns, re the sports matter.
I'm not familiar.
Okay. You know what? I don't have the acronym in front of me, but it's the Collective Windsor Essex County Secondary School Athletic Association. So 2 A's, a couple of C's, I think a couple of S's, or whatever. They have policy as well.
Thank you for the help.
Mhm. I just wondered if you can inquire. Okay, thank you. And we're a member of that. Next, I hope I have the pronunciation. Beth Saint-Denis? Or do you prefer St. Denis?
Either works.
Okay, you're on and you have 5 minutes. There you go.
Thank you. Good evening. My name is Beth St. Denis. I identify as a Christian adult female. I am a mother, a godmother, and a lifelong resident of Windsor. I am also an English public school supporter. To clarify, I pay taxes to the public school board. I do thank you for the opportunity to speak here tonight at the Policy and Bylaw Committee meeting. I have read Section 6 of the Governance Bylaw in its entirety and find that my presentation meets the criteria. I also feel my presentation is within the jurisdiction of the Policy and Bylaw Committee's responsibilities. The trustees updated their governance bylaws on December 3rd, 2024. Many citizens of Windsor-Essex County were not aware that the governance bylaws were changed. One of the most notable changes was eliminating delegations from appearing at school board meetings. This was a shock to many residents, with the trustees voting almost unanimously to abolish the speakers list on October 15th, 2024. Delegations were the last option for citizens to present concerns in person to items on the agenda at the regularly scheduled board meeting. The trustees have taken away 2 critical tools for public engagement. I am aware that the governance bylaws suggest other ways to contact the school board, such as directly emailing their trustee and emailing the communications department. In my opinion, these are not sufficient methods for public interaction. I have emailed my trustee as well as other trustees and on multiple occasions with no response. My emails have been respectful and have asked for clarification on specific issues. I am sure you can appreciate my frustration that as a taxpayer, I am being ignored through these mechanisms. I am curious why the taxpayers were not consulted about these governance changes before they were implemented. Would it not be a logical conclusion to consult the people you are accountable to on how the public should be able to interact with the trustees? I have other serious concerns that fall under your scope of practice as the Policy and Bylaw Committee. It is imperative that I speak to you directly with my concerns regarding the gender identity and expression in school regulation. I have read the document and submitted my feedback. However, you need to hear directly from a citizen on a regulation that I believe needs serious revisions. This document states, quote, all students have the right to use a washroom or change room that best corresponds to the student's lived gender identity, regardless of the student's sex assigned at birth. The K1 survey results from 2023 reflect that the vast majority of students, 89%, identify as male or female. This policy puts the health and safety of 89% of our students at risk. What is your action plan to deal with the psychological harm that will come from letting boys into girls' washrooms and change rooms? This policy facilitates a breach of security to vulnerable children. Quote, there is no age limit on making an accommodation request. Young students have the same rights to privacy and to have accommodations made on their behalf with or without their parents' guardians' knowledge, end quote. Parents or guardians are the child's legal authority. Parental authority refers to parents' rights and responsibilities towards their children from the minute they are born until they turn 18. Under their parental authority, parents make decisions that affect their children's well-being. Under parental authority, parents have these rights and responsibilities towards their children: custody, supervision, physical and psychological protection, health and safety, and education. As a child's legal authority, parents or guardians must be consulted on every aspect of a child's life. School board employees do not have the right to interfere with a parent-child relationship under any circumstances. These are extremely concerning policies. The job of this committee is to do intensive research and make informed decisions that are in the best interest of our students. You have been entrusted to represent the citizens of this community in the area of public education. This is a serious responsibility that should not be taken lightly. One way to rebuild public trust is to release the feedback submitted to the Greater Essex County District School Board on the gender regulation. I am extremely confident that the majority of citizens who submitted feedback want this policy completely revised. As public servants, you have a duty to take public feedback and implement it for the best interests of the children. I appreciate the opportunity to bring these issues to your attention. Please consider reversing your decision to prevent the public or delegations from speaking at regular school board meetings. I implore you to release the public feedback on the gender identity and expression in school regulation. Making significant revisions to this regulation is doing what is best to protect the innocence of our children. Thank you.
Thank you, Ms. St. Denis. And if you have any questions or clarification from Trustee Cook or online from Trustee Hatfield. Any questions or clarification? And I have none. Yours is very straightforward, and we'll take that. Thank you very much.
Thank you for your time.
Seeing no further delegations, we're on to staff reports are nil, and